Good afternoon, everybody. Thank you for joining us today for today's online talk, which will be starting soon. Thank you for your patience. For those who are here, thank you for waiting. And before we start this session, we'd like to share a short video introducing the firm, our firm, Malaysian and Associates.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody, to our online talk today. Today's topic will be on company directors and fiduciary duties. I'm Denise Pang, a senior associate with Malaysian Associates, and I'll be your moderator for today. So before we begin, allow me to introduce our firm. Malaysian Associates is a mid-sized law firm that was founded in 1985 by Datuk Malaysian. Our able team today comprises of 27 lawyers and a support team of 21. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today by working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment or industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both of our corporate and dispute resolution teams. So today's talk is part of MWKA's online talk series. By way of background, we have been hosting and organizing these monthly lunch talks in our office since 2013, some of which were broadcasted live as well. But with COVID-19 and during the MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. If I may introduce the speakers for today, the first speaker is Sebastian Liu, who is a senior associate with our firm. Sebastian mainly deals with corporate litigation and company law advisory. He graduated from Cardiff University and was called to the English bar in 2015. Our second speaker for today is Joseph Kaur, who is an associate with the firm, and his area of practice is corporate litigation, company law, advisory, land disputes, general and commercial litigation. Joseph graduated from University of Malaya. Now, this is today's top points, and if I may just introduce our first speaker of the day, Sebastian, over to you.
Thank you, Denise, for the introduction. My name is Sebastian Liu, and I will be the first speaker for today's online talk session. I will begin today's session by speaking briefly on company directors as fiduciaries, and the types of statutory duties and the fiduciary obligations of directors. In Malaysia, the two most common business structures under the Companies Act 2016 are private limited companies, also known as Sendiri Berhad, and public limited companies, also known as Berhad. A company that is incorporated under either business structure are limited by shares and are a separate legal entity from their shareholders, meaning that they can own, buy, or sell property, enter into legal contracts or arrangements, and sue or get sued in courts. As a separate legal entity, such limited companies continue to exist irrespective of changes to its shareholding. In essence, the company owns its assets and is responsible for its own liabilities and are separated from its directors and shareholders. A company's separate legal personality exists for so long as it remains registered. The continuing existence of a company may be terminated by its liquidation, or after the name of the company has been struck off from the register, whereby the company shall be dissolved. As mentioned in my previous slide, both a Sendirian Berhad and a Berhad are limited by shares. Therefore, the ownership of either a Sendirian Berhad or a Berhad is represented by the share capital injected into a company. Therefore, shares, sometimes also known as stocks or equity, are instruments denoting some form of ownership in the company issuing them. A shareholder, sometimes also referred to as a member, is the holder of the shares or stocks. And these individuals can either be an individual or a non-human legal entity, like a company or corporation, for example. As shareholders do not own any of the company's assets directly and are neither directly liable for the company's debts, in general, their exposures are confined to the extent of their investments and are insulated. The shareholders may only be made liable in limited circumstances where the corporate veil can be lifted, for example, where there exists an element of fraud. However, for today's session, we will not go further into lifting the corporate veil. This could perhaps be a discussion for a different session. So as mentioned in the previous slide, the liability of the company is limited and ring-fenced to the company itself, and generally does not extend to shareholders and the directors. The shares only give their holders for the time being some typical rights, normally those to dividends, voting in shareholders' meetings, surpluses to liquidation, and corporate information during AGMs. Shareholders do not have a direct say in the management of the company. This is left exclusively to the board of directors of the company. At most, the shareholders' involvement in management is the right to vote at general meetings, to reconstitute the board, or to appoint or to remove directors. So as the board of directors are left in charge of the management of the company, what exactly is a company director? The statutory definition of a director under Section 2 of the Companies Act 2016 is any person occupying the position of director of a corporation by whatever name called and includes a person in accordance with whose directions or instructions the majority directors of a corporation are accustomed to act, and an alternate or substitute director. In addition, Section 196 sub 2 of the Companies Act 2016 requires that a director of a company shall be a natural person who is at least 18 years of age. This means that a director, unlike a shareholder, must be a living human being of age, distinguished from an artificial legal person created by operation of law, such as a corporation or a company. So who can be a company director? The general requirements to be a company director in Malaysia are that the person must be at least 18 years of age. The person must not be an undischarged bankrupt in or outside of Malaysia. The person must not be convicted of certain offences in or outside of Malaysia under Section 198 sub 1 B to E of the Companies Act 2016. These are, for example, offences related to the promotion, formation, or management of a corporation, offences involving bribery, fraud, or dishonesty, offences related to the breach of duties and responsibilities of directors, such as to act in good faith in the best interest of the company, offences involving the improper use of the company's property and opportunity or the position of director, and offences related to the failure to keep proper books or accounts explaining transactions and the financial position of the trade or business of the company. For directors who have been convicted or imprisoned for the offences mentioned in my previous slide and under Section 198 sub 1B to E of the Companies Act 2016, the person may hold office as a director 5 years after the date he was convicted, or if he was sentenced to imprisonment 5 years from the date of release from prison. In situations where an individual has been disqualified, the Companies Act provides that any person who has been disqualified as a director under Section 198 sub 1 may be appointed to hold office of the director with the leave of the official receiver or the court in the case if the person is an adjudged bankrupt, or with the leave of the court if the person is convicted or imprisoned for the offences under Section 198. The company director is a fiduciary. Fiduciary duties exist between a party who stands in such a position of power and trust in relation to another party that the law requires the former to act in the latter's best interest. As directors are entrusted with the management of the company's business, they are viewed by equity as standing in a fiduciary relationship with the company and are therefore subject to duties that stem from this fiduciary relationship. As fiduciaries, directors are expected to act bona fide for the benefit of the company as a whole, and they are precluded from exercising their powers for any collateral purpose. In addition, they may not profit from their position or put themselves in a situation where their duty to the company and their personal interests may conflict. I will now move on to the second segment of my online talk and to discuss the types of statutory duties and fiduciary obligations expected of from a director in Malaysia. Under the Companies Act 2016, there are three fundamental duties of a company director. A director's duty to exercise powers for a proper purpose and in good faith in the best interest of the company. A director's duty to exercise reasonable care, skill, and diligence, and a director's duty to avoid conflicts of interest. These fundamental duties can be further subdivided into other statutory duties that a director is duty-bound to diligently follow, such as, for example, a director's disclosure obligations or to satisfy the business judgment rule. I will now speak on the first fundamental duty, which is the duty to exercise powers for a proper purpose and in good faith in the best interest of the company. Under Section 213, sub 1 of the Companies Act 2016, a director of a company shall at all times exercise his powers in accordance with this act for a proper purpose and in good faith in the best interest of the company. To elaborate, directors have a duty to exercise their powers for the proper purpose, and if the directors exercise powers for any other purpose, then in such circumstances, any action or transaction that had arisen from the exercise of such powers is voidable. So it is immaterial that the directors of a company honestly consider the transaction to be in the interest of the company if the decision of the directors for the transaction was motivated by a collateral or an improper purpose. So how does the court determine proper from improper purpose? I will use the leading company case of Howard Smith versus Ample Petroleum to provide perspective on the proper purpose rule. The Howard Smith case involves three parties: R.W. Millers, the subject matter of a takeover, Ample Petroleum Limited, and Howard Smith Limited. So the facts. R.W. Millers was the subject of a takeover between Ample Petroleum Limited and Howard Smith Limited. The Ample faction, together with another company, Bulk Ships, owned approximately 55% of the issued share capitals of R.W. Millers. The directors of R.W. Millers preferred Howard Smith Limited as they had created better takeover terms, including future employment for the current directors. The directors of R.W. Millers then issued 10 million of new shares in favor of Howard Smith Limited, claiming that the dominant purpose of the issuance was to raise capital to finance the purchase of two tankers. The effect of the issuance was that the Ample faction's shares were diluted from 55% to 36.6%. In effect, the issuance of the new shares served to block the Ample faction's rival bid, where without the issue, Ample could have completed acquisition of R.W. Millers. A summary of the Privy Council's finding was that although the directors had acted honestly and had the power to make the allotment, to alter a majority shareholding was to interfere with that element of the company's constitution, which was separate from and set against the directors' powers, and accordingly, it was unconstitutional for the directors to use their fiduciary powers over the shares in the company for the purpose of destroying an existing majority or creating a new majority. And that since the directors' primary object for the allotment of shares was to alter the majority shareholding, the directors had improperly exercised their powers and the allotment was invalid. Based on the decision, it is clear that the action was improper, as although R.W. Millers needed capital, the issuance of shares was also intended to allow Howard Smith Limited to take over. Therefore, although the directors were honestly trying to advance the interests of the company, the power to issue shares must not be improperly exercised. And in this circumstance was to forestall a takeover bid from one faction, which therefore constituted an abuse. Moving on, the second fundamental duty of a director is the duty to exercise reasonable care, skill, and diligence. Under Section 213, Sub 2 of the Companies Act 2016, a director of a company shall exercise reasonable care, skill, and diligence with the knowledge, skill, and experience which may reasonably be expected of a director having the same responsibilities, and any additional knowledge, skill, and experience which the director in fact has. The standard is an objective standard, and it applies to all directors regardless of whether a director is holding an executive position or not. Such duty also applies to senior management of a company. My colleague Joseph will discuss more on the fiduciary obligations of executives shortly during his segment of this online talk. Continuing from my previous slide on a director's duty to exercise reasonable care, skill, and diligence, a director is deemed to have satisfied the requirements there if he or she makes a business judgment. The requirements to satisfy the duty under Section 213 of the Companies Act is provided under Section 214, Sub 1. A director is deemed to have made a business judgment where he or she is able to prove all four requirements were met. The first, the director makes the business judgment for a proper purpose and in good faith. The second, the director does not have a material personal interest in the subject matter of the business judgment. The third, the director is informed about the subject matter of the business judgment to the extent the director reasonably believes to be appropriate under the circumstances. And the fourth, the director reasonably believes that the business judgment is in the best interest of the company. In essence, the business judgment rule acknowledges that no commercial decision is ever certain, and the commercial reality of operating a business is that not every decision is going to turn out favorably. This legal principle provides a defense which protects a director from claims or civil liability for loss incurred from the decision made, perhaps to repel any accusations that the director was acting without care, skill, or diligence, despite having made reasonable or well-intentioned business decisions that failed. Moving on to the third and final fundamental duty of the director is the duty to avoid conflicts of interest. Under the Companies Act, a director's fundamental duty is to act in the best interest of the company, and to do so would require a director to avoid and to deal properly with matters that present conflicts of interest. There are two common types of conflict: situational conflict of interest and transactional conflict of interest. Examples of situational conflict of interest would be where an individual becomes a director of another company dealing in similar business in the company he or she holds office in, therefore may result in conflicting duties. Or secondly, having a family member working for a direct competitor. An example of transactional conflict is where a director has a personal interest or a material interest in a proposed contract or transaction the company intends to enter into, such as the sale of a director's personal asset to the company which he or she holds office in. The directors of a company are duty-bound to scrutinize any transactions that involves a potential or actual conflict to ensure that their personal interests are not advanced at the expense of the company and the shareholders. However, the obligation to avoid a conflict situation does not mean a conflicted director must avoid a transaction altogether. The Companies Act 2016 provides methods to appropriately deal with such scenarios. This leads me to the director's disclosure duties. In the event where conflicts do arise, the principal duty of a director is to make full disclosure of the potential or actual conflict. Under Section 221, a director of a company, when faced with a case of conflict, must declare the nature and extent of his or her interests, whether direct or indirect, including that of the spouse of a director or of a child, which includes the adopted child or stepchild of a director at the meeting of the board of directors. Section 221 sub 6 of the Companies Act 2016 reads that every director of a company who holds any office or possesses any property where duties or interests may be created in conflict with his duties or interests as director shall declare the fact that the nature, character, and extent of the conflict at the meeting of the directors of the company. A contract entered in contravention of Section 221 shall be voidable at the instance of the company. The directors may seek authorization at board or shareholder level to authorize a potential or actual conflict. To mitigate the risk of conflict where it involves interested contracts or proposed contract, a director must adhere to the guidelines under Section 222 of the Companies Act. Section 222 sub 1 provides that, subject to Section 221, a director of a company who is in any way, whether directly or indirectly interested in a contract entered into or proposed to be entered into by the company, unless their interest is one that need not be disclosed under Section 221, shall be counted only to make the quorum at the meeting of the board, but shall not participate in any discussion while the contract or proposed contract is being considered during the meeting, and shall not vote on the contract or the proposed contract. Therefore, a director in a situation of conflict, whether directly or indirectly, should not participate in any board level discussions or decisions made in respect to the conflict or potential conflict. The director in such a situation of conflict may be present only to form quorum at the meeting of the board. The failure to adhere to the requirements here would render a contract voidable at the instance of the company. Now, what happens when the director breaches his or her duties? As the duties are owed to the company and not the individual shareholders, the company is the proper plaintiff or claimant to enforce the occurrence of fiduciary breaches by directors. This is unless there is a possibility for the minority member to bring a derivative action on behalf of the company. There are three ways to bring an action against a director who has breached his or her fiduciary duties. The first, by the members. This is, however, unlikely, but can be brought via a general meeting. The second, by the directors. This is usually the normal and most common way for an action to be taken. Or the third, by the liquidators, if the company is insolvent. So if the company is solvent, the benefit will pass on to the shareholders. And where the company is insolvent, the benefit will be passed on to the creditors, and therefore the liquidators will be representing the creditors in any actions against a director who has breached his duties. Once a breach has been established, the remedies available for breach of a director's fiduciary duties are the return of the property and or the confiscation of any profits made, rescission of any contracts or arrangements, or equitable compensation, being a personal monetary remedy available for losses flowing from equitable wrongs, such as the breach of a fiduciary position. Briefly, a few words on the first remedy, the return of property and confiscation of profits. If property is taken in breach of fiduciary duties, the director holds the property in trust for the company and may be ordered to restore the same to the company. Further, where a director has profited from the breach of fiduciary duty, the principal objective of the equitable remedy is to confiscate the property and to give it back to the company. For the purpose of this remedy, it is to deter directors from breaching their fiduciary duties and not merely to compensate the company. The principal remedy is to account for any profits made from the breach. On that note, that is it for my part. I will now pass the floor over to my co-speaker, Joseph, who will be speaking on the obligations of directors during a winding up and briefly on fiduciary obligations of company executives. Thank you.
Thanks, Sebastian. But before we move on to the second session, a few reminders to the participants today. If you have any questions, please don't forget to type it in the Zoom Q&A chat box at the bottom of your screen. And also, please be reminded that this talk does not constitute legal advice. If you require specific legal advice to your matter, please contact us for complimentary legal consultation. Details will be given at the end of this talk. So without further ado, if I may introduce the second speaker, Joseph, who will be speaking on directors' duties and obligations during winding up proceedings. Over to you, Joseph.
Thank you, Denise and Sebastian. As Sebastian mentioned earlier, the duties of directors generally times where the company is solvent is owed towards the company. So they have a duty to act, a fiduciary duty, in fact, to act in the best interest of the company when the company is solvent. However, when the company becomes insolvent, and most commonly in situations of the winding up of companies, this duty is slightly different. So when a company is insolvent and is undergoing winding up, the director's primary duty is owed towards the creditors of the company as compared to the company itself. Now, there are two primary duties of a director in times where the company is undergoing winding up or is insolvent. The first is the duty to cooperate with the liquidator of the wound up company. And the second, as I've mentioned earlier, and I will go into more detail on that in the following slides, is towards the creditors and to act in their best interests. Now, first on the duty to cooperate with the liquidator. Now, when the company is insolvent and is wound up, the liquidator takes over the affairs of the company and runs the company in the place of the directors. So it is then that it is the director's duty to cooperate with the liquidator so that the winding up and liquidation process goes smoothly. Failure to cooperate with the liquidator may result in criminal sanctions, such as imprisonment and fines. So it's very important that the directors cooperate with the liquidator. Directors are also required to hand over, and this is a statutory requirement, to hand over, cause to be handed over, all books, property, and records over to the liquidator. And this is in relation to the company's assets and the company's affairs, right? Now, thirdly, the liquidator also has the power to apply for the public or private examinations of directors in court. So this isn't done very often, but it's often sought where there is a suspected wrongdoing on part of the director or there has been lack of cooperation. A director can then be ordered to attend court in order to be cross-examined and questioned by the liquidator. So as you can see, it's very important during the process of winding up and liquidation that the directors of the company cooperate with the liquidator so that the winding up process and the liquidation process, the distribution of the assets to the creditors, can go smoothly. Now, having said that, as I mentioned, the main duty of the directors in winding up at situations of insolvency is the duty to act in the best interests of the creditors. And I'll illustrate this with a case or case study, as we like to call it in the corporate world, right? Of CIMB Bank Berhad against Jaring Communications Sdn Berhad, where the court decided and held that an important aspect of the facts of this instant application is that the company was already insolvent. And a significant consequence of this state of affairs would be that the interest of the creditors of the company displaces that of its members. So in insolvency, the interests of the creditors are paramount. And as we'll go on to see a bit later, there are instances where the directors have acted against the interests of the creditors. And mainly, these are instances where the directors have tried to defraud the creditors, which has caused personal liability to be imposed on the directors themselves. And as I will explain a little bit later as well, although fraud may seem like a very drastic term to use, it's actually not that difficult to trigger fraud under the Companies Act winding up procedures. Let's have a look at it. So let's start with Section 540 of the Companies Act 2016. It's quite lengthy, but the point is, if a director is found to be conducting fraudulent trading or have an intention to defraud the creditors of the company, the director can be made personally liable. All right, that's the summary of Section 540 of the Companies Act that I've pasted over there. So the court in that situation, on the application of the liquidator, see the liquidators back in, or any creditor or contributory being the shareholders of the company, may, if the court thinks proper to do, declare that any person who was knowingly a party to the carrying on of business in that manner shall be personally responsible without any limitation of liability for all and any of the debts or other liabilities of the company as the court directs. So we'll have a look at a case later in my next segment where even family members of the directors may be made liable. Although the details are slightly nuanced, that's the general principle. So these are some common instances where directors have been held to commit fraudulent trading to defraud the creditors. Firstly, in conducting or approving transactions whereby the company's assets were preferentially transferred to select creditors. Now, to give some context to this first point, in a winding up situation, all the creditors are ranked equally. Of course, there are certain different classes of creditors. First, you have your secured creditors. In creditors, for example, the most common ones are the banks, where properties were charged, companies' assets were charged to these creditors in exchange for financing, in exchange for credit. So these are your secured creditors, they'll rank first. And then the company will have to pay off statutory payments to government bodies, and then that is followed by the wages of the employees, and then finally the unsecured creditors. So in each class of creditors, every creditor in that particular class ranks equally. So in approving transactions whereby companies' assets were preferentially transferred to select creditors instead of having it being distributed equally, it can constitute fraudulent trading. So directors in winding up have to be aware of that and be careful. Secondly, declaring dividends from monies which were not profits. This is quite obvious that it is considered fraudulent trading. You cannot do that. Thirdly, intentionally allowing the company to be wound up when the company was clearly able to pay its debts. I'll have a case to illustrate this later. And any other circumstances where directors have acted in a manner as to defraud creditors, including where preferential treatment is shown to specific creditors, as I've explained earlier. One thing to note is that this list is an exhaustive list, meaning these are not the only things that can constitute fraudulent trading, although these are the more common ones. There are many other instances if it can be found that the directors have been acting in a manner to defraud creditors or trying to make preferential payment. Those facts can also constitute fraudulent trading. So be aware. The other thing to take into consideration and to bear in mind, as I mentioned earlier, payment to defraud creditors out of the company's assets. It is important to note that any transfer or any transaction, essentially, that is done 6 months prior to the winding up, the winding up petition, is deemed fraudulent and void. All right. So of course, you can rebut this presumption or this deeming provision, but it will be deemed at the first instance to be fraudulent and void unless proven otherwise. Any transfer or assignment by a company of all its properties to the trustees for the benefit of all its creditors shall also be void. So sometimes you'll have situations whereby directors transfer properties to trustees. So because it's a trust, it does not no longer form part of company's assets, right? So this is also considered void. So we'll have to take note of these things in the winding up process. The other provision in the Companies Act, there's another provision, also provides that once a winding up has been granted by the court, any transaction after the winding up petition has been presented is also be subject to become void, right? So these are the things you have to take into consideration. So as I mentioned earlier, let's have a look at a case to illustrate the situation, the somewhat odd situation where directors can be considered to be fraudulently trading when they fail to oppose the winding up. So the case of the Tuan Sulaiman and Tay against Wong Po Kun and another. In this case, there are two directors of Bistari Lands Sdn Bhd. Okay, this is the company that was being wound up here. Were sued in their personal capacity for fraudulent trading. Bistari Land was sued by the Tuan Sulaiman and the Malaysian government in different suits for debts owed. It's not really important what these debts are, but just bear in mind that these are debts owed by Bistari Land to the Tuan Sulaiman and also to the government. So both Tuan Sulaiman and the Malaysian government filed to wind up Bistari Land. So the court held in this case that the directors of Bistari Land were personally liable for fraudulent trading because Bistari Land received 3 tranches of payment, clearly enabling them to pay the debts to the Tuan Sulaiman and the Malaysian government. So instead of bringing those funds into the company and paying off the debts, these payments were dissipated into the directors' personal accounts. And Bistari Land paid all other creditors except the Tuan Sulaiman and the Malaysian government. See, preferential payment. And the directors of Bistari Land intentionally allowed Bistari Land to be wound up. So in this case, the court ordered the directors to make payment to the liquidator into the company's funds, and then the liquidator will distribute the funds accordingly. So it's important to look at this case because sometimes there are cases whereby directors have looked at the company, they don't want to continue the business of the company, and intentionally allow the company to be wound up, notwithstanding the fact that the company has sufficient funds to pay off those creditors. So in such situations as well, as you can see, the court has said that this is fraudulent trading and the directors are personally liable. So in a nutshell, the director's duty during the winding up process is owed primarily to the creditors to, number one, ensure that all the creditors in each class are treated equally, right? And second, to ensure that the company's assets are liquidated smoothly and to cooperate with the liquidator in that process. Finally, I want to speak briefly on the fiduciary duties on other company executives. So other company executives include your CEO, your CFOs, and certain even very high general manager, very high managerial positions. So there are times where CEOs, CFOs, or COOs are not appointed from the group of directors of the company. Will these people, or will the holders of these offices have a fiduciary duty to the company, as directors do? And the short answer is yes. But let's have a look at the details. Now, CEOs, CFOs, and COOs, and any other person primarily responsible for the management of the company share similar duties and responsibilities as director. Now, this is not made up by me. It's stated in Section 210 of the Companies Act. It says that for the purposes of this subdivision, being director's duties, excluding certain reporting obligations, which primarily need to be signed off by the director. But in relation to the general duties of the directors under the Companies Act, in addition to the definition of director in Section 2, which my colleague Sebastian has explained earlier, a director includes Chief Executive Officer, Chief Financial Officer, Chief Operating Officer, or any other person primarily responsible for the management of the company. All right? So the word primarily responsible for the management of the company here is quite important, as we will see later. So let's have a look at the case of Simbayan, and we'll have a look at an illustration that shows this. A group of companies, this is a Simbayan group of companies, sued its former group CEO for breach of fiduciary duty during his tenure. So the CEOs, there are 5 defendants in this case. Number 1 is the CEO himself. Number 2 is his mother, his wife, number 3, and along with 2 companies related to the CEO. So these are companies that he has set up, without the approval of the board of directors. The CEO was sued for breaching his fiduciary duty, and the other defendants were sued for dishonestly assisting the group CEO in breaching his fiduciary duties. The main issue here is that the CEO was sued for making secret personal profit from several transactions that he had authorized during his tenure. If you remember, as Sebastian mentioned, directors cannot be in a position of conflict of interest. And the same applies to senior management officials as well, as I've shown in Section 210 of the Companies Act. Now, the court found that the CEO was liable for breach of fiduciary duties. His mother, wife, and 1 related company were also found to be liable for dishonestly assisting him. I've not placed it in the slides, but there are a list of transactions the CEO has done, one of which is setting up a business company without the approval of the board of directors of this group or this company. So he set up a company allegedly for doing online commerce, but some of the monies that were taken out from the company to set up this new company were paid into his personal accounts. So it's sort of a scam transaction, if you see where I'm going here. So instead of putting all the money that was taken out from his company, without the approval of the board of directors, by the way, into this new business that he was allegedly setting up, some of the funds were diverted into his own accounts. So this is quite a clear-cut case, and there's a whole list of things that he have done. The citation is there, and you can look up the case if it's online. So the judge, Justice Wong Chi Lin, in this case, she held that as the group CEO, the first defendant certainly owed a duty of fiduciary and of fidelity towards the plaintiffs. And these duties were also well within the first defendant's knowledge, and he was well aware of such duties owed towards the company. The other point, as I mentioned earlier, about senior management, the court in this case also referred to another case which the Court of Appeal decided in. So a few important principles were summarized here. And there's a distinction between senior management positions and normal employees, as we'll see in a bit. So in the Court of Appeal case, the summarized principles are as follows. Firstly, only persons holding senior management positions or duties similar to directors. All right, so in this case, the court was referring to fiduciary duties. Very senior employees were in the position of special trust and responsibility with regard to the management of the organization and assets or fiduciary duties to the company. Whereas, to contrast that, normal employees, so your day-to-day employees, owe a duty of fidelity to their employers, which are different from fiduciary duties. So the distinction here, although it's a fine one, but for the purposes of knowledge, in cases of breaches of fiduciary duty, the recourse is to sue generally the directors or the office holders for breaches of fiduciary duty and asking them to pay. Whereas breaches of fidelity for your normal employees, that is subject of employment law and subject to the employment law regime, your labor courts, your industrial courts, which we will not touch on today. So that brings me to the end of my presentation. To sum up, senior management officials expressly mentioned, though the ones that are expressly mentioned are CEOs, COs, CFOs, and others. That depends on the facts of the case, and we'll really have to look at how senior he is and what kind of position he holds, whether it's one of special trust and responsibility to determine whether he owes a fiduciary duty. But generally speaking, senior management officials, they also, like directors, owe fiduciary duties to the company. So that's an important thing that we should take note of. That's all for my presentation today. I'll sit back to Ms. Denise.
Thank you. So thank you to both our speakers for their insights today. We hope everybody will have a clearer picture on the duties of the directors during the execution or the management of the company, and also during the winding up process. Now, before we conclude, we would like to take questions from the floor. If I'm looking at the Q&A chat box, we do not have any questions there, but there is one question, I believe it's for you, Joseph, in the chat. And this question is from Titus Pereira. What is the trigger date of the 6 months of winding up process? Is it the date of LOD or creditors take court action to wind up? Joseph, would you be able to take this question?
Yeah, sure. I'm not quite certain what is meant by date of LOD or creditors take court action to wind up, but generally, there are many ways to wind up a company. So the most common one is where the company is unable to pay its debts, and I believe that is the one that is being asked here. So in that circumstance where usually a judgment is obtained, or if there's very clear-cut proof that the company is unable to pay its debt, we issue what is called a 466 notice, so a notice under Section 466 of the Companies Act. And I believe that perhaps is what is meant by the LOD here. So it's 6 months from then for the company to either pay up or be wound up. So it's not where the creditors take court action to wind up, because if you are going under the ground, the Companies Act, that the company is unable to pay its debts, then your 466 notice will have to come before you put in your winding up petition. Of course, if you go under other grounds, for example, just and equitable grounds and all that, we will not go into that. But if that is the case, then you will skip the 466 notice process. But in the case of 466 notice, you have to put in your 466 notice first. So perhaps that's what you meant by LOD. I hope that answers the question.
Thank you, Joseph. There is one final question. So I think we'll take this before we conclude due to time constraints here. What if a director who is not familiar with the financial matters as compared with other directors who are more experienced? Example, an architect compared with financial personnel.
I think in this situation, it is clear that all directors owe a fiduciary duty to the company. And as Sebastian mentioned earlier, there are certain duties that the director must perform. And if he performs his duties according to what is required of him under the law, then he will not be made liable. So in this case, if it can be showed that whether it is an architect as a director or financial personnel as a director, for example, if he comes into a situation of conflict, so he makes a secret profit or he has family members in a competing business, whoever it is, whether you are an architect or financial personnel, you are not supposed to do that, as Sebastian mentioned. And if you do that, then you will be made liable, regardless of what your background is. I think that addresses the question.
Thank you very much, Joseph. That will conclude our Q&A session. Before we conclude, we have a few announcements to make. Please allow me to share my screen. Please feel free to register for our upcoming talk on the 2nd of December 2022, which is on living trust versus testamentary trust and what's the difference. This talk will be the two speakers for this talk and Ms. Rachel Ng from our Malaysian Associates. And secondly, please fill in the feedback form and tell us what you think about our talk. The link to the form will be posted in the chat. And thirdly, if you would like further updates or you would like to attend further talks on legal topics that you are interested in, please feel free to follow our social media accounts. We are available on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Also, just a reminder, we do offer a complimentary 30-minute video consultation with our lawyers. So if you require any further or more detailed questions or a case that requires specific attention, please feel free to fill up the form. You can scan the QR code available on the screen. That is all for today. Thank you for joining us, and we hope you found today's session informative and helpful. Thank you, everybody, and we'll see you at our next talk.